Hi folks, welcome to RJ Impact. Sam took the stand this week. On Thursday it was in front of the judge without the jury present, and on Friday in front of the jury. As a reminder, Sam Bankman-Fried is on trial facing 7 charges relating to fraud and money laundering associated with his running and being CEO of FTX, a cryptocurrency exchange. There are further charges that he will face next year. The reason for the with and without jury was that on Thursday the judge, Lewis Kaplan, wanted to agree the lines of argument that were going to be presented to the jury, and in some sense it was a trial run of the testimony he did give on Friday. In respect of the questioning on Thursday he faced from his defence team, his responses were fairly succinct, giving fairly straightforward answers. However, when the prosecution asked him more probing questions, he became a man with evidently poor memory skills. He didn't really recall anything that could be considered incriminating, leading to frustration from Judge Kaplan. "Listen to the question and answer the question directly," Kaplan reportedly stated at one point, and one commentator made the point that his Thursday testimony was apologetic, forgetful, and evasive. Let me give you a taster of that. So the question was whether he believed Alameda Research, that's FTX's sister company, had a right to access FTX's customer funds. Deep breath. So I should preface this by saying I'm not a lawyer. I'm not giving a legal interpretation of this. I'm just giving as best I can what my memory is. And the parts of this that jibe with that, I'm not trying to give a definitive legal ruling on what this does or doesn't say. I'm not sure that I would quite answer yes to the question as you most recently phrased it. I'm going to try as best I can to give the answer that I believe, which is that as at least I remember understanding it at the time, FTX either itself, or I think as actually happened, without FTX as an intermediary, customers' fiat funds would be sent to Alameda bank accounts. FTX would retain effectively a debt from Alameda for those, and in the lien section here, phew. Judge Kaplan commented that he had an interesting way of responding to questions. He paused for uncomfortable amounts of time, bowed his head, and appeared to struggle for answers at times. For example, when he was asked to point out the section in a contract between Alameda and FTX that allowed the trading firm to spend customer money deposited to its accounts. Puzzlingly, at least for this narrator, Cohen for the defence said that SBF would not formally at least rely on an advice of counsel defence, and that is where the defendants say that they acted reasonably as they relied on counsel's advice, and so should be able to rely on that. In other words, it was the counsel's fault. Cohen for the defence said it would be difficult for Sam Bankman-Fried to say, "I asked my attorney about every one of these theories of frauds." His key testimony, that's Sam Bankman-Fried's, came on Friday, and as expected, he testified that he didn't defraud the customers or take their funds. We did eventually get to hear some of the substance of his defence, as he repeated a number of times that he had followed the counsel of former FTX lawyer Dan Friedberg and California law firm Fenwick and West when deciding on whether to retain internal documents, fund venture capital investments via loans to executives, or allow Alameda to receive FTX customer deposits. Friedberg is actually being sued by the debtors of FTX for his role, and in the court documents they say he was the fixer for SBF. Let's get to it. Mark Cohen for the defence asked SBF whether he defrauded or took customer funds. Bankman-Fried said, "No, I did not." He said the biggest mistake was having no risk management team at FTX, which led to significant oversights. He acknowledged that a lot of people got hurt when the FTX collapsed in November last year. "We thought we might be able to build the best product on the market. It turned out basically the opposite of that," he told the judge. "A lot of people got hurt, customers, employees, and the company ended up in bankruptcy," he said. And he did admit to these significant oversights. He wanted FTX to be the best exchange on the market, but it turned out to be basically the opposite. Now, rather than try to go through his testimony chronologically, I'm going to highlight the key areas of his testimony by issue. Self-deleting messages. We got an answer to the self-deleting messages about the alleged frauds, and much has been made by the prosecution on this. SBF said that lawyers approved of FTX auto-deleting communications, and he believed it was allowed under the FTX data retention policies. He also stated that the company encrypted communications due to concerns about hacking attempts and ex-employees interfering in the business. Alameda Research. We know that a lot of customer funds were diverted to Alameda by FTX, and he, SBF, threw a lot of blame in its direction, and particularly his former love interest Caroline Ellison. He stated repeatedly that he'd advised her to hedge Alameda Research assets against potential losses, but that she refused. Bankman-Fried testified that FTX borrowed funds from Alameda Research with the understanding that the firm had enough assets to cover its liabilities, when in fact it did not. SBF, the human being. Rather than this caricature of a genius, nerdy, gawky, awkward, shy, altruistic and offbeat businessman, the defence tried to humanise him. They tried to debunk a lot of this. For example, they asked about his habits as an executive and the unusual setup of the FTX employees in what has been called a polycule in a sprawling Bahamian apartment. Who was responsible for being the public face of FTX? Cohen asked. I was, SBF said. It was an accident at first. I hadn't intended to be a public face of anything. I'm somewhat introverted naturally. And the co-living setup of FTX, it served as an office away from my office. He also stated that his relationship with Ellison began in 2020 and had dissolved by spring 2022. It was Ellison's fault. A lot of time was spent on the last few months of Alameda and FTX, and the defence blamed Ellison for the collapse. I became fairly concerned about Alameda's risk. It had not hedged against the market crashes despite the many conversations about hedgings, and we'd heard this point for a second time now. If there had been a sufficient quantity of hedges made in the previous year, it would have offset the major losses, he said. And Cohen showed the court a list that Ellison had created called Things Sam is Freaking Out About, and at the very top of this list was the word hedging. Were you freaking out, he was asked. I don't tend to show a lot of freak-outness, but relative to my standard, yes, he said. Another message was shown to the court, and this was stating that Alameda Research may need to shutter because it had not hedged. And this read, the fact that we should have hedged alone cost more in expected value than all the money Alameda has ever made or ever will make, and that's the kind of critical mistake we're likely to make if I'm not actually running the show there. The decline and fall. Here the defence discussed the impact that the decline of the whole crypto world in 2022 had on FTX and Alameda. Bankman-Fried had said that when the whole crypto market fell at the time, it had a large impact on Alameda Research, which had leveraged long in the market. The nearly $40 billion in assets it had of late 2021 had fallen to just $10 billion in June 2022. And again, on the hedging, I would check in periodically to see if Alameda had in fact hedged, and was told each time that it had not done so but was planning to do so in the near future. In summer 2022, when Ellison approached executives and said she was concerned the firm might have just gone bankrupt, Bankman-Fried said about this, she was nervous. She asked what we should do, what we should tell Alameda's lenders. I was very surprised and very concerned, Sam Bankman-Fried said. Data and the New York Times test. FTX used encrypted communications as a protective measure, Bankman-Fried said, explaining that the company was concerned about hacking attempts, as we've heard, and ex-employees interfering in the business. He knew about the FTX data retention policy and said about that, my understanding was that there were groups of documents and records of communications that need to be conserved for the foreseeable future. And the New York Times test? SBF said, basically anything that you wrote, there's some chance it could end up on the front page of the New York Times. Poker. Cohen showed a photo of Bankman-Fried holding playing cards, which the prosecution previously displayed in court. Now, he was asked, why did you hold playing cards? Bankman-Fried appeared to chuckle and said, I compulsively fidget with things in my hands. For a while I had decks of playing cards. I would go through a deck a week or so before the cards themselves got worn out. Eventually he transitioned to fidget spinners, he said. Ever play poker? Cohen asked. No, I haven't for years. Did you ever go to Las Vegas? Objection! And that's all we heard of that. Work ethic. The defence tried to demonstrate that SBF was hopelessly overloaded and thus could not have known how wrong things were going at FTX. They demonstrated how FTX went from single-digit millions daily to tens of billions daily in 3 years. Did FTX at that time have a risk management department? We sure should have, but no, we did not, he said. How much time did you work in a day? On a light day, 12 hours or so, or on a heavy day, 22 probably, he said. How many emails did you receive in a typical day? Thousands, he said. I was shooting for about an inbox with 60,000 unread messages in it. It would be a slightly less overwhelming number that way. I didn't usually succeed. The FTT token. Bankman-Fried answered questions about FTT, and between him and the defence, they showed how crucial it was to the demise of FTX. So in late 2022, when customers were rushing to withdraw money, following reports that Alameda's loans were extensively buoyed up by FTT, meaning that a possible decline could make everything crumble, Bankman-Fried tried to make the FTT token sound like a creation that was good for the company and the customers. The purpose of FTT was to be a token that users of FTX could buy and trade if they wanted. Did you ever hear of the term buy and burn? Cohen asked. Yes. So one of the features of the FTT was the buy and burn, Bankman-Fried said. What that refers to is every week FTX would take 1/3 of the money that it had made that week and it would use that to buy FTT tokens and burn them. That means effectively get rid of them. So for instance, if FTX had $3 million of revenue in a week, it would take $1 million of those dollars and use that to buy FTT tokens, effectively giving the value to the existing FTT token holders. Risk management and Alameda. Alameda was a customer of FTX, so that it was allowed to borrow from it, he said. So long as we believed that the risk was being managed, which is to say, so long as we believed its assets were greater than its liabilities, we didn't care if the user, withdrew funds and used them to buy muffins, to pay business expenses, to invest, or anything else. FTX's risk engine, which as simply put as possible was software intended to close positions that fell below a safe level, malfunctioned at one point. We've heard about this already in a previous testimony. It grew into a ridiculous set of erroneous trades, Bankman-Fried said. Once the humans realised what was really happening, we shut it down. Cryptocurrency, I know nothing. When FTX was started, SBF said he didn't know much about it. I had absolutely no idea how they worked, he told his lawyer on the stand. I just knew there were things that you could trade. He said he thought that there was maybe a 20% chance that FTX would be successful, and maybe an 80% chance that would fail. Summary. Well, here are my takeaways on what's happened anyway. We've had the defence so far, obviously, and SBF and his lawyers have managed to score a few points. They've provided a narrative, at least, as to the reliance on legal advice SBF was given. They've shown here is someone who's admitted mistakes, particularly in not having risk management practices. And the fact that the terms of service, or some terms of service, allowed some customer funds to be used by FTX was fairly good for them. They've shown how SBF was aware of the risks that Alameda placed on the company and pressed that Caroline Ellison do something about it, hedge essentially. And the secret messages, well, they were about data retention and protection against former employees and hacking. The big gap in all of this, to my mind, well, that's he was CEO. And he did allow customer funds to be used. He knew about it, let it continue. To my mind, a jury may well see that as an unforgivable step, despite the nuances of the case. He's had a friendly question and answer session so far. Let's see how he performs in front of the prosecution. And so, as the hand of subscribe presses the notification bell to remind it to tune into the prosecution's turn next Monday, all that remains for me to say is bye for now.